Okay, so once again, counsel, the contact is being recorded to provide a record upon request. And this is a hearing being convened on Thursday, June 27, 2024, before the Department of Motor Vehicles and the Poway Driver Safety Office concerning the driving privilege of, in accordance with the provisions of the California Vehicle Code. The Director of the DMV has appointed me, Driver Safety Hearing Officer Diane Lefferts, to hear this matter. I will be acting as a neutral fact finder. I am prohibited from and will not act as an advocate for the DMV or law enforcement. My role is to review the evidence provided, ask clarifying questions of witnesses if necessary, and make legal rulings and determinations under the relevant statutes as necessary. Pursuant to the California Vehicle Code, I am required to review documents provided to the department by law enforcement, as well as the department's records. You will be provided an opportunity to object to the admissibility of those documents and why they should not be considered by the department. And counsel, please state your name and business address.
My name's Richard Jorgensen. I'm with the law firm of Jorgensen Salberg. We're located at 15137 Woodlawn Avenue, Tustin, California, 92780. Waive appearance for the licensee.
Great, thank you. Any opening remarks today, counsel?
Reserve.
And the issues are as follows. Did the officer have reasonable cause to believe respondent was driving a motor vehicle in violation of section 23152 or 23153 of the vehicle code? Was respondent lawfully arrested? Was respondent driving a motor vehicle at the time that he had 0.08% or more by weight of alcohol in his blood? And at this time, I have documents that have been provided to the DMV by law enforcement or other agencies. Vehicle Code sections 13557 and 14104.7 require the department to review and consider these documents for the matter. Exhibit 1 is CH 21 and older officer's statement, more commonly known as the DS-367. Shows your client as the driver, an arrest date of April 21st of 2024, and prepared by Officer Zalto of the Needle CHP. The ID number is 18343, and the exhibit, sir, is moved into evidence unless you have an objection.
My objection in reviewing it, typically under, and I'm sure you're familiar with Evidence Code Section 771, and it provides that any documents that are reviewed in preparation for trial or testifying at trial, actually it's, if I'm sure you're familiar with it, but Evidence Code Section 771, I think it says, subject to subdivision C, which is something else, if a witness either while testifying or prior thereto uses a writing to refresh his memory with respect to any matter about which he testifies, such writing must be produced at the hearing at the request of an adverse party. Unless the writing is so produced, the testimony of the witness concerning such matter must be stricken. And I'm requesting that the breath strip, he obviously relied on some document, he indicates, and there was even indicated on the DMV discovery or the face sheet, that there was a breath strip. If you look at the department's DS 2044 Rs in Romeo, which was revised back in 2019, and it's marked that there's a chemical test result along with the DS 367. The fact that I'm requesting it, is the department able to rely on it? Obviously, the officer must have reviewed the test strip in preparation of filling out that DS 367. I'm just asking if the department can and will produce that test result consistent with its requirements under Evidence Code Section 771.
And I mean, I understand your objection, counsel, but quite frankly, if you look at the box where the results are recorded on the face of the DS-367, parenthetically, way off to the right, it says attach a copy of the results if available. So the department does move forward if the results are, obviously signed and properly, written in the boxes there. And we go forward with it as is. Now, whether or not it was kind of a training issue or if they are told, period, as long as the results are somewhere, because of course I don't work with support staff, so I don't know how they're trained, if you will. But I think that they check that box, period, as long as the results are there in some format. It does not necessarily equate to a breath strip when they check that box, as long as the chemical results are somehow included in the packet. That's the only real explanation I have. But I mean, obviously, if you disagree with our decision or the outcome of this hearing, I mean, you can, again, request a departmental review or file a writ.
All right. Well, just so I can state my objection, I'm sure you're aware of the California Code of Regulations, Title 17, that outlines the standards for forensic alcohol analysis, including procedures for conducting and documenting breath alcohol tests. These regulations require the results of the test be properly recorded and preserved. I'm asking for those, and let me give you. It's according to, I think it's Title 17, Section 2 1221.3, so it's 1221.3. The operator must record the results of the breath test, including the subject's breath, the concentration, and all other relevant information, such as the date and time of the test, the name of the person taking the test, and the name identification number of the person conducting the test, and all that has to be preserved. Obviously, that officer relied on something. He read something, and under Evidence Code Section 771, the department's required to either produce what he relied upon or strike the testimony. Is the department able to produce the strip?
No, but as I said, the department, because it's the, if you will, the certification statement that's on the front page of the DS-367, because the breath test machine operator in this case was the officer. So he signed under penalty of perjury that was the time that he administered the breath test. Those were the results that he obtained. But if you see his signature there, his badge number is there. And again, that essentially due to that certification statement, if you will, that there's nothing that requires that we absolutely have to have the accompanying breath strip. We do a great majority of the time because, as you pointed out, most of the time it's included in the arrest packet, or the arrest report itself. It's usually attached, but in this case it was not attached.
All right. Well, and so the department's under 771. I'm requesting it. Is the department not going to produce it?
Exactly. That's what I'm saying. I mean, we just rely upon what we have.
All right. And then, this time I asked, if it hasn't been produced, I'd ask that the officer's testimony, the DS-367, be stricken at this point, consistent with Evidence Code Section 771, paren A. 771, paren A. Yep. Can the hearing officer strike it this time?
Again, we do not strike it simply because those results are certified under penalty of perjury by the peace officer.
And that's his testimony. The affidavit's this declaration, the affidavit under penalty of perjury is in lieu of. If you review Government Code section under the Administrative Procedure Act 11513 and 11514, that's the department's allowed to consider testimony via declaration as long as we receive it 10 days prior. But that's his testimony. There's some case law I could provide saying that his testimony has to comply with generally with the Administrative Procedure Act and also the Evidence Code to some extent. And under the Evidence Code, I'm asking for it to be stricken because the document he relied upon in preparing this testimony, the DS-367 declaration, is not attached. Is the department not going to strike the? You just make a ruling one way or the other, and we can get a judge to review it. Is the department not going to rule on that motion?
Well, I'm going to overrule your objection. Is all I'm saying, sir. I'm going to overrule your objection. I understand where you're coming from with that. However, I'm going to overrule the objection and move the documents into evidence. And obviously, if you disagree with you on this, if you will, obviously you can take it a step beyond this, of course.
Of course, but I wasn't objecting. I was moving the department. I was moving the hearing officer to strike the declaration under 771. So I understand you overruled the objection, but I'm asking on a motion to strike pursuant to Evidence Code Section 771. Can I get a ruling on that?
Well, no, the department is not going to strike that, again, that evidence, if you will.
All right. So you're denying my motion to strike declaration under 771. Understood. All right.
And again, that once again, sir, is in reference. But I mean, I'm going to bring your concern about checking that box off on the 2044 to someone down the line to see if there could be more clarification. So that someone's not expecting that necessarily equates to a breath strip. In any event, Exhibit 1 is moved into evidence. Any other objections, though, outside of that, sir?
Not to Exhibit 1. To the driving under the influence arrest investigation report, my objections would be, this is an unsigned, it was reviewed on, it appears 5/8/24, is that when it was reviewed? So, 2 or 3 weeks after the report was prepared. So this is an unsigned, undated document for all intents and purposes. That we don't know when the officer actually completed it. It was reviewed, and I know the department often relies upon Evidence Code Section 1280, Record of Public Act, or 1271, a business record, for admission over the hearsay objection. This document obviously contains information and facts that it not only supplements the DS367 but goes well beyond that, and that additional information does not supplement but provides additional information beyond supplementation is inadmissible under the hearsay rule, and also under, and we already talked about Government Code Section 11513, Government Code Section 11514 is in it being hearsay. And because the document wasn't prepared at around the time, and the department doesn't know when it was prepared, it appears it's undated, unsigned. It was reviewed on 5/8/24, which was, a few weeks after the arrest was made. So it doesn't come within the requirements of the temporal proximity of Evidence Code Section 1280 and 1271, and should be excluded on that basis, and not considered anything above and beyond the information contained in the DS367 should be excluded because it's not supplementing the information, and then the document itself should be excluded because it's a hearsay document and it doesn't fall in the purpose of administrative hearsay for supplementation, and it's also unsigned, undated, so it doesn't meet the requirements for the exception to hearsay under the Public Record Act or the Business Record, and it should be excluded, not considered. Thank you.
So, counsel, your hearsay, Government Code 11513, Government Code 11514, Evidence Code 1280 and 1271, objections to Exhibit Number 2 have all been noted for the record. However, overruled, and the document's been moved into evidence. And that, of course, was Exhibit 2. And Exhibit 3 is the driving record dated today, June 27, 2024. It is 4 pages in length and moved into evidence unless, counsel, you have an objection.
I do. The fact it's dated today, I've never seen a copy of it. I'm sure the hearing officer is well aware that any documents that are going to be considered by the department have to be produced 10 days in advance. It gives me an opportunity to actually send a deposition, or not, send a subpoena for the appearance of any custodian records or anyone involved in the preparation of that administrative document. The fact that it wasn't provided to me, I've never seen a copy, is wholly inappropriate. The department can't consider a document that hasn't been produced. There's a certain level of transparency is supposed to be involved in these hearings. The fact that I've never seen the document is wholly improper for the department to consider, move into evidence and consider a document that's never been produced to date. It said the hearing. I wish I would have really appreciated the opportunity to, and this is related to the DS3672, if I knew that you weren't going to strike his testimony consistent with Evidence Code Section 771, I could have subpoenaed the officer, or maybe the custodian of record, or the person who was responsible for calibrating and keeping those whatever the breathalyzer machine was, the make and model of that breathalyzer. I could have subpoenaed them to determine whether or not it's accurate, consistent with Title 17 of the California Code of Regulations. But additionally, I would have subpoenaed somebody if there were any discrepancies or any issues. But the department prejudiced the licensee's case by not allowing the licensee to subpoena the custodian record for that document by not producing it. We've never seen it and shouldn't be considered. Equally so, the department is to prejudice the licensee by not producing the documents upon which the affiant, the declarant's DS367's testimonies relied upon, just to determine whether or not there's a certain level of accuracy. They call it, under Evidence Code Section 80 and 1271, they call it veracity or trustworthiness. We don't have that same level of verification for veracity or trustworthiness, and those documents should be excluded. Thank you.
Counsel, your objection to the driving record has been noted, however overruled. The document's been moved into evidence. If you'd like a copy, I can scan it to you right now. There have been no additions to the record. It should, in fact, be identical to the one that you have. If nothing has been transmitted to this gentleman's record since the one that's marked discovery. We use it solely, quite frankly, during these hearings to identify the person, to make sure we've got a current address on them. That's it.
All right, understood.
The closing argument first today, counsel.
No, my objections. It's inappropriate for the department to rely upon the officer's testimony because I asked for any documents that he relied upon in preparation for his testimony. It wasn't produced, wasn't stricken. If the department followed the requirements of Evidence Code Section 771, it would have been stricken, and the department could not have made its prima facie case. Additionally, there was indication that the breath strip would be produced. It was on discovery form. The fact that there was representations, a misrepresentation upon which we relied upon our detriment. The fact that there was supposed to be a breath strip, it wasn't produced. We could have subpoenaed somebody to get it, but we didn't. So the fact that we weren't afforded afforded the opportunity to subpoena the 771 document, the actual breath strip, to verify that it was kept in conformity with Title 17 of the California Code of Regulations with respect to the forensic requirements, or the requirements for reliable and valid results is a concern. Additionally, with respect to the additional statements in the driving under the influence arrest investigation report, those statements should be excluded. The fact that the department is not excluding the hearsay testimony in those hearsay statements in that document is inappropriate and prejudices the licensee's case. The licensee's prejudice in the fact that we could have subpoenaed those witnesses if we knew that you were going to move the evidence, the hearsay document. We could have subpoenaed it and actually had the declarant, the person who made those statements, available to testify live. But the fact that the department's considering it and didn't give us appropriate notice, the fact that they were going to, the hearing officers were going to consider hearsay documents that are outside the administrative hearsay exception is prejudice in the case. Additionally, the fact that the department moved into evidence a document we've never seen further prejudices the licensee's case, and on that basis, the suspension should be set aside. That's it. Thank you.
The department will take the matter under submission and render a decision within the next 15 days with both a copy to you and to your client through the mail. This concludes the hearing. We're going off record. And thank you, sir. Have a good rest of your day.
Thank you, ma'am.
Thank you, Bob.